Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, FCC versus AT&T and the companion case, Verizon Communications versus the FCC. The Supreme Court decided this 8-1 on June 4th, 2026. Chief Justice Roberts wrote the majority. Justice Thomas filed the lone dissent. Bottom line, the FCC can issue 9-figure fines through its in-house administrative process without a jury because those fines don't force payment. Before the government can collect a single dollar, it must prove its case to a jury from scratch. 8 justices called that structure constitutional.
And Justice Thomas agreed with the legal theory, but said the court gave the carriers nothing. Before we get into it, follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. Questions about this case? Reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, let's proceed. So here's the story. Your smartphone pings a cell tower every few seconds. Each ping registers your location. AT&T and Verizon know where every tower sits, so they can pinpoint where you sit at virtually any moment of any day. That data carries real commercial value.
And both carriers monetized it.
Until 2019, AT&T and Verizon ran location-based services programs. They sold customers real-time location data through intermediaries to third-party providers, roadside assistance, healthcare services. Sounds legitimate until it got abused.
Badly. In 2018, news reports exposed the Securus scandal. And as you may recall from our preview episode, this incident sat at the heart of the FCC's case. Securus sold location services to law enforcement. Officers theoretically needed valid legal authorization, a warrant, for example, before accessing someone's location. A Missouri sheriff obtained a customer's real-time location by uploading what one court called utterly irrelevant materials. The safeguards collapsed completely. A law enforcement officer tracked hundreds of people, including a local judge, with zero lawful authority.
The FCC's Enforcement Bureau launched an investigation and concluded that AT&T and Verizon violated Section 222 of the Communications Act, the federal law requiring carriers to take reasonable steps to protect customer location data. After its in-house process, the FCC dropped the hammer. $57,265,625 against AT&T, roughly $47 million against Verizon.
Both paid under protest, because paying first, then suing stood as the only reliable path to challenge those orders in court. Pay to fight or don't pay and wait indefinitely. That choice framed the entire constitutional dispute.
Both carriers filed legal challenges and got completely different answers.
AT&T went to the Fifth Circuit, the appeals court covering Texas, Louisiana, and Mississippi. The Fifth Circuit sided with AT&T. By the time the commission issued a forfeiture order, it already found the facts, interpreted the law, adjudged guilt, and levied punishment, all without a jury. Constitutional violation.
Verizon got the opposite. The Second Circuit, New York, sided with the FCC. An FCC forfeiture order doesn't compel payment. The Department of Justice must file a separate civil lawsuit before anyone can collect. No binding payment obligation, no Seventh Amendment problem. One court said unconstitutional, the other said perfectly fine. Classic circuit split, and as we flagged in the preview episode, that split sent this case straight to SCOTUS. The court took both cases January 9th, 2026, and heard argument April 21st.
So what exactly did the court need to decide?
Does the Seventh Amendment require a jury before the FCC can issue a forfeiture order? The text drives everything. The Seventh Amendment says, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. $20. That threshold dates to 1791.
$57 million clears that bar. But the critical phrase, suits at common law. Does an FCC administrative proceeding count as a suit? And does the jury need to appear at the penalty stage? Or does a jury opportunity downstream, in a later collection lawsuit, satisfy the Constitution?
At argument on April 21st, Jeffrey Wall, arguing for AT&T and Verizon, opened by calling this a straightforward Seventh Amendment violation. The FCC imposed over $100 million in civil penalties, and the companies lacked any way to demand a jury. He put it squarely inside jarcossy, the 2024 Supreme Court decision that struck down the SEC's in-house penalty process.
But the court pushed back hard from the jump.
Justice Kagan pointed to two older cases, Meeker from 1915 and Hof from 1899, and told Wall, the court already upheld preliminary agency findings as long as the jury gets the last word in an enforcement suit. Where's the problem?
And then Chief Justice Roberts delivered the exchange everyone in that courtroom remembers. Roberts asked Wall, "At the end of the day, aren't you really just talking about a PR problem? You get labeled a lawbreaker, but you don't owe anything until a jury decides." Wall pushed back. Even a parking ticket creates a legal obligation, even if the government must come after you to collect. That back and forth previewed exactly how the majority framed its answer.
All right, how did 8 justices work through it?
Chief Justice Roberts started with the constitutional framework. The Seventh Amendment doesn't demand a jury at every stage of a legal dispute. It requires that before legal rights get conclusively resolved, a party gets the chance to put the facts before a jury. The word conclusively carried everything. Two older cases anchored the analysis. Meeker versus Lehigh Valley Railroad, a 1915 case, involved the Interstate Commerce Commission issuing orders directing rail carriers to pay damages for overcharging customers. A shipper could only enforce those orders by winning a subsequent jury trial, where the ICC's findings served as opening evidence only. No Seventh Amendment problem. Then Ex parte Peterson, a 1920 case, a court-appointed auditor made preliminary factual findings as prima facie evidence, meaning starting evidence, before the jury. Again, no problem. The jury retained the final say on every fact. The FCC's scheme fit both.
Why? What made the FCC's orders non-binding?
3 things. First, the FCC holds zero power to execute on a forfeiture order. It cannot seize assets, attach property, or obtain liens. The statute doesn't authorize it. Second, no penalties pile up for non-payment. Interest doesn't run on the amount. Third, Section 504(c) of the Communications Act actually bars the FCC from using an unresolved forfeiture order against a company in future regulatory proceedings. The statute itself protects the company that declines to pay.
So you can just ignore the order?
Legally, yes. The order creates no enforceable payment obligation. And here's the piece that drove the constitutional result. Section 504(a) of the statute says forfeitures get recovered through a trial de novo. De novo, Latin for fresh start, meaning the government must prove everything from the beginning, as if the FCC never found anything at all. The jury starts with a blank slate. The FCC's 100-page order, years of investigation, counts for nothing in that courtroom.
The agency does all that work and the court ignores it?
For collection purposes, completely ignores it. Justice Kagan made this exact point at argument. It turned out to drive the decision. She told Wall, "The agency makes its determination, but a court can start entirely over with a jury." The majority said that structure satisfies the Constitution.
In Jarkazi, the SEC case the carriers leaned on actually proved the majority's point. The SEC held administrative tools to collect immediately. It could garnish wages, deduct penalties from tax refunds, no court required. And even when the SEC did go to court, the jury heard only whether the penalty got paid, not whether the underlying violation occurred. The SEC held the final word on the facts. The FCC holds none of those tools. Completely different structures.
Justice Kavanaugh flagged something sharp at argument here. He told Wall, "It looks like you've won on the law going forward," but he pressed the sharper concern. Those orders used bold, all-caps mandatory language. Is liable for a monetary forfeiture. Payment shall be made within 30 calendar days. Didn't that language mislead the carriers into paying? The majority declined to answer, left it entirely open.
The court also dismissed the carrier's second argument, unconstitutional conditions. That doctrine says the government can't coerce you into surrendering a constitutional right. The carriers argued the scheme forced an impossible choice: pay and get deferential court review, or refuse and wait indefinitely for a jury trial that might never come. The majority rejected it. The Seventh Amendment attaches only to suits. The only suit in this scheme sits in a DOJ collection action. If DOJ never files, the jury right never attaches in the first place. Justice Jackson pressed Wall on this at argument. She couldn't understand why the carriers wanted the government to come after them. The majority agreed the argument didn't fit.
So, the holding?
8-1. Chief Justice Roberts for the majority. The FCC's forfeiture orders under Section 503(b)(4) don't conclusively settle the carrier's legal obligations. The Commission's factual findings carry no binding force. Issuing those orders without a jury doesn't violate the Seventh Amendment. The Fifth Circuit, which sided with AT&T, got reversed. The Second Circuit, which sided with the FCC, got affirmed.
Now, Justice Thomas dissented, but not how you'd expect. Thomas didn't dispute the majority's legal framework. He agreed the orders should count as non-binding going forward. He agreed the carriers deserved a de novo jury trial at the enforcement stage. He wrote separately because the majority applied the correct legal theory and handed the carriers nothing.
So, he agreed on the law, disagreed on the remedy. Thomas argued the carriers deserved relief because nothing, at the time they paid, signaled those orders carried no binding force. The Commission's ordering clauses commanded in bold is liable for a monetary forfeiture. Payment shall be made within 30 days. The Commission's own regulations required full payment by a fixed date. Courts across the country, as of 2024, routinely denied regulated parties a de novo jury trial in enforcement actions. Circuit after circuit limited review to the factual basis of the agency's action. No carrier in 47 years ever received a jury trial in a Section 504 enforcement action.
So the government collected over $100 million. Then argued in this very litigation, the orders amounted to advisory documents all along.
Thomas called that out directly. He wrote that the majority penalized AT&T and Verizon for complying with a government order they, in good faith, believed binding, for preserving their objection at every stage, and for litigating so effectively that the government changed its position years later. At argument, Justice Thomas asked Wall, "What can the court do when the government already switched positions?" Wall answered, "At minimum, declare the orders beyond the agency's authority, ultra vires, and order refunds." Thomas would have given the carriers that path.
All right, time for what this actually means. For any company the FCC regulates, carriers, broadcasters, cable operators, the calculus flips. A carrier that receives an FCC forfeiture order can now decline to pay without accruing interest, without penalties for non-payment, without the FCC using that refusal against the company in future proceedings. Then it waits. DOJ holds a 5-year window to file a collection suit.
And if DOJ never sues?
The forfeiture evaporates. No collection ever happens. The fine disappears.
Now here's where the next fight begins. AT&T and Verizon already paid $57 million and $47 million respectively, over $100 million combined. The court explicitly declined to address whether the carriers can reclaim that money, what forum would handle the claim, or what the merits of a refund argument might look like. Justice Thomas's dissent and Justice Kavanaugh's questions at argument practically drafted the brief for their lawyers.
And for the FCC going forward?
The court confirmed the constitutional structure, non-binding order, then a full de novo jury trial. But that structure now depends on DOJ actually filing collection suits. If DOJ declines or delays, the FCC's enforcement leverage evaporates. And the decision drew a sharp line across the broader regulatory landscape. Agencies built like the FCC, no immediate collection tools, full de novo jury trial downstream, likely survive Seventh Amendment scrutiny today. Agencies built like the SEC, immediate enforcement mechanisms, limited jury review, remain in jeopardy under jarcossy. That line carries enormous stakes across financial regulation, environmental enforcement, and consumer protection law.
One more open question from argument. Several justices, Sotomayor, Barrett, pressed hard on whether paying the fine truly stood as a prerequisite for Hobbs Act review, the mechanism carriers used to challenge FCC orders in the courts of appeals. Justice Sotomayor suggested the carriers may never have needed to pay at all. The court declined to rule on it, noting only that the parties litigated on the assumption that paying first stood as a requirement, without endorsing or rejecting that premise. That question now hangs open.
Bottom line,
The FCC can still fine companies, but those fines now operate as formal charges, not final judgments. Before the government can collect $1, it must prove the case to a jury from scratch. And for AT&T and Verizon, who paid over $100 million under the old understanding, that fight just moved to the next case.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And look, if the Supreme Court just told the federal government that a 9-figure fine amounted to a polite suggestion, the refund lawyers already picked up the phone.
Talk to you soon.